So Ralph Baxter is a Renaissance man of his own right. He's been a fellow with our center for several years. He knows the world of the law firm like not many others. He was a law firm leader of one of the most successful law firms and has really changed many of the practices of that firm, as I understand. And then he's also gotten very actively involved in the legal tech community as an advisor to many exciting ventures. And so Ralph will be moderating the session on the legal framework in which legal innovation is trying to take root and exist. So with that, I'll turn it over to Ralph.
So good afternoon, everyone. Thank you for staying. We're a little late, but this is important stuff we're going to share. But before we start, when Mary O'Carroll told that story about being in that law firm that billed by the hour and, unlike the other ones, raised those rates, that was horrific. I was there when that happened. Yeah. It's a true story, and then Mary's history speaks for itself thereafter. So all of us are here today because we care about the intersection of law and technology. And we're here, at least some of us are still here, because not only because we care about it, but because we want to make law work better. We want to change the way legal service works. And that isn't easy for lots of reasons. We're going to talk about one of those reasons that is kind of a foundational reason it's not easy and it's harder than it needs to be, and that is the restrictive and prescriptive rules that govern the practice of law, but really, in effect, govern legal service more broadly. And they in the following ways that are vital, and I wanted to say it to you in this way because it relates to what we're really trying to do. It affects, limits who can do what in your organization. It limits how much you can pay the people who work in your organization, and it prohibits you from giving people who aren't lawyers a stake in the ownership of the organization, so that it, so that they can benefit as the organization is successful. No serious business runs itself that way. This, in turn, has dramatic impacts on what you can do. It limits who you can hire. It limits who you can retain. It limits your ability to raise capital beyond the money of your own partners. The good news is that there's real progress in changing these rules, and this panel is going to talk about that. We have one of the leading experts in the entire country on how the process of changing these rules is proceeding, and Lucy Rica, who is known to all of you because of all her years here at the Stanford Center on the Legal Profession, which she left for a while and now is back. But she also was the first leader of the new regulatory organization created in Utah, and Lucy's going to share with us her perspective on what's happening out there in the momentum for change and what's happened in particular in Utah and Arizona. Then Maya Markovich is going to talk about the organization she now leads, the Justice Technology Association, which is supported by a number of entrepreneurs and other people who want to see change, and they are an agent for change in this world of regulation. And then we're going to hear from two companies that have taken advantage of the changes in Utah and Arizona. We're going to hear from Steve Harmon, who we all know from his years of activity here at CodeX during his career at Cisco. He's now the general counsel and vice president of Elevate Services, and they have gotten an ABS and are participating under the new rules in Arizona. And then we'll hear finally from John Warren, who's CEO of Estate Guru, and they have gotten permission to work in the sandbox in Utah. So, Lucy?
Sure. I think I have to get the clicker, so. Okay. So I'm just going to give a quick overview of what's happening across the country. I'm not that tall, so with regard to reg reform. Couple of foundational principles. The United States has one of the most restricted legal markets in the world. There are two main facets to these restrictions that functionally impede, diversification and growth of the market. The first is Rule 5.4, which is the rule of professional conduct that says lawyers alone can own and manage legal practice businesses, right? No ownership, investment, management, joint venture, compensation from non-lawyers. So pretty significant restriction impeding the business of the practice of law. The second one is the unauthorized practice of law, which says that anything a lawyer does, including simple legal advice, only lawyers can do it. Anyone else who does it in some states is criminally liable, and corporations cannot do it. Employees of corporations cannot do it for the public. So these are the two main rules that have kind of always been at the forefront of considering how to rethink the regulation of the practice of law. And for 100 years, over 100 years, very little changed. But in the past 5 years, and in particular in the past 2 years, we've seen pretty significant change happening, albeit in certain jurisdictions. The first is that I'll touch on is Arizona. Arizona in 2020 completely eliminated Rule 5.4, and it now allows non-lawyer ownership and investment through entity provision of legal services, which are regulated as alternative business structures. This model of regulation is taken directly from the UK. So it's very, very similar in almost all respects to what has been permitted in the UK since 2007, essentially. As of the last time I checked, Arizona has 18 ABSs authorized, including LegalZoom and Elevate. Utah took a different approach, and that's the one that I've been up to my neck in. But we use this mechanism of regulatory sandbox to facilitate the waiver of Rule 5.4 and the unauthorized practice of law. So both of those things are on the table. Entities in the sandbox can have non-lawyers practice law within them. They can also partner with non-lawyers in any form, essentially. And we can also do one-off waivers that are different from those two things. This is wrong. There are now 40 entities authorized. We had 6 more this week. So, and that's in 2 years. So this is moving. I mean, we now have non-lawyer owned entities, non-lawyers practicing within entities in Utah and Arizona. I want to talk for a second. Mary and Peter did a great presentation of the corporate legal market. And I think Steve is going to touch on this as well. That is absolutely on the table in both of these spaces, but I think we all are much more familiar with that market. It's sort of it's been an easier market to innovate in because of you're selling to general counsels, and ultimately they're responsible for the practice of law issues, right? So there's been, and Mary is a really good example of this, there's been a lot more innovation, a lot more use of, as Mary said, disaggregating the legal practice, right sourcing. None of that can happen for small businesses who don't have general counsel or individual people. And so I want to talk for just a second about the opportunity in both of these states. I had my friend Dr. Tom Clark do a little back of the envelope calculation for me, and it would appear, both these numbers are probably underestimates, but we think that there's about 4 million legal problems annually that are unserved in Arizona. 1 million of these are low-income people. 2 million are probably in the moderate middle income, people who could pay something for legal service, for legal help in some facet. At least 1 million for small business. And small business is probably particularly underestimated because we have almost no data about how small businesses interact with legal problems, and we know they probably have a lot of them. In Utah, 2.5 million unserved legal problems annually. 1 million for low, about 1 million for middle, and 500,000 for small businesses. Again, these are probably really low estimates. But I wanted to talk about that because, I think Utah and Arizona, people think of them as sort of small, discrete markets that may not have larger implications and may not be worth jumping into in terms of using new business models or using legal tech in innovative ways. I would argue that they're not. There's a lot of unserved need and a lot of growth that can happen within those markets, and I think John from Estate Guru will talk a little bit about what he's doing in this regard. But also, it's sort of it's a potential to get to market first in a space that I think we're hopefully seeing a tipping point. I'm probably optimistic, but I think that we have not seen the kind of problems that people are afraid of. In Utah and Arizona, we haven't seen them in the UK. And I think there's a potential to look at these two states as a get-to-market opportunity before there's even a regulated market. So I would encourage all of you to think about that, and particularly in the context of Utah, legal tech offering legal advice is absolutely on the table. That is not on the table anywhere else, including in the UK. And so, well, that's not true, actually. I think it is on the table in the UK, but it's not on the table anywhere else in the US. And so I would encourage you all to think about engaging with the sandbox. We have really interesting data coming out of it. We've got a lot of really interesting participants, and I'm happy to talk to all of you after about it. So these are some of the states that are exploring reform. California, I'm on the working group along with my colleague David Enstrom. It's going to be a long haul, but we've got some really great people and I think a lot of committed folks. North Carolina and Washington are seriously looking at legal sandboxes. Michigan is considering a lot of this. So there's other states that are moving. The other quick piece I want to talk about is what I've touched on so far is sort of state Supreme Court-driven regulatory reform. There is also, I think, really significant pressure coming from impact litigation, and most specifically the suit that was recently filed by Upsolve against the state of New York. And this suit says New York's unauthorized practice of law, doctrine and restrictions and I think rule are essentially violating folks' First Amendment right to be able to access simple, free legal services, legal advice in particular. So Upsolve is a legal tech company. They're a B corporation or nonprofit, and they have filed suit saying, you should allow us to partner with community organizers to offer legal advice for free. So there's a lot of pressure coming into this space, and I hope that you all will be aware of it and considering it as you build these extraordinary tools and businesses moving forward. So I'll pass it to Maya.
Maya.
Okay, so thank you so much. This is really just the highlight of my week, at least, to be up here with everybody. Let me just start by reiterating the magnitude of the problem that we're dealing with, as Lucy and Ralph alluded to. So the US is ranked 126 out of 139 countries when it comes to the affordability of access to the legal system. In 75% of matters, at least one party is self-represented, and it's often much higher than that. 5 billion people in the world cannot access the legal system. Legal aid and pro bono are doing unbelievable work, but they are overwhelmed and under-resourced. So there's this massively underserved population in our communities that is not able to access their rights, and we need different models. Technology can and should be part of the solution. So all over the world, there are people working to help consumers bridge that gap in the access to legal services. Here are some examples you might be familiar with. There's dozens more every day. Courtroom 5 offers a low-cost AI-driven service that helps people represent themselves in complex civil cases. Users learn the litigation process, how to analyze the elements of claims, how to make good decisions on what to file at each step, find supporting legal authority, and draft legal documents throughout their cases for themselves. Hello Divorce provides a pathway to a friendlier, simpler, and less expensive divorce by combining software that makes it easy to complete and file these incredibly complicated forms with access to a team of legal and financial experts who really thoughtfully help resolve conflict between spouses. Easy Expunctions creates a fast track to justice with guaranteed results, leveraging technology to assure that their customers have a streamlined and cost-effective way to clear their own criminal records. They are informing and empowering people interacting with the criminal justice system. And People Clerk empowers individuals to navigate small claims disputes in an easy and affordable way. Their platform helps people prepare, file, and serve their small claims lawsuits, and they're a public benefit corporation as well, with a conviction that people should have access to justice, regardless of their social, economic, or cultural circumstances or background. So these companies, as well as Upsolve, which manages, it helps folks handling consumer debt challenges, are examples of this nascent sector of justice tech. Companies that are designed to improve or open access to the exercise of one's legal rights, improve outcomes, and increase equity in a system that is stacked against them. So these companies are doing incredible work, and they're changing lives, but they are fighting an uphill battle, and the innovation is hampered by these outmoded regulatory constraints that Lucy mentioned. So without regulatory change, direct-to-consumer justice tech companies cannot help these millions of Americans who need it because they're stuck. This Gordian Knot term is often used as shorthand for this intricate or an intractable problem, which is solved by finding an approach to the problem that renders the entire perceived constraints moot. So cutting the Gordian Knot is used to describe a creative or decisive solution to this seemingly insurmountable problem. So that's where we're at now. Some of the challenges that justice tech companies faced are very well laid out in Upsolve's recent complaint in New York about the outdated rules of professional responsibility, including things like vagueness of the unauthorized practice of law statutes and revenue sharing restrictions. So these companies, as Lucy described, cannot hire lawyers directly to provide legal advice, because with very limited exception, only law firms can collect fees directly from clients who are asking for that legal advice. Otherwise, it's revenue sharing or fee splitting, and that's prohibited. These companies can't even hire paralegals with decades of experience to give any sort of advice to consumers unless they're supervised by a lawyer in a firm. So what is allowed, however, is a lawyer with 0 years of experience in that area of law supervising a paralegal within a firm structure to deliver the same advice. So these companies are living also under the constant threat of looming UPL lawsuits, and those are threatened monthly, and they can easily bankrupt any of these startups. So these outmoded regulations that are governing the unauthorized practice of law and revenue sharing are really standing in the way of ameliorating the access to justice crisis. The principles are incredibly important, but there are no clear standards, and it's often treated as, we'll know it when we see it. By bars that are often set up to protect lawyers' market share rather than protect the consumer. And they're right, it is very difficult to provide any clear standards, but that really is leaving innovators in the, having to set aside a budget for compliance efforts to address any bar that might have questions about their operations, which is incredibly stifling and wasteful. And by the way, on a related point, even when justice tech companies are not directly battling UPL and related regulations, there's this entrenched bias against pro se litigants that is really hampering progress. So this is a huge barrier because not only does it impact the consumer's experience, but can also inform the outcome. The customers of Easy Expunctions, one of the companies that I mentioned earlier, have reported that they rarely receive the benefit of the doubt. And even when their documents are flawless and the statute is clear, some of the judges, prosecutors, and clerks claim that the pro se litigant is the one that's incorrect, and they won't even engage, even when Easy Expunctions will support their customers by intervening and even with a letter citing the relevant law, they don't get any attention. So the bottom line is we need more flexibility so organizations can offer more solutions to customers. We need to refocus on the consumer and not on attorney protection. So there are alternatives to hiring attorneys and dealing with those matters that aren't desirable or cost-effective for a lawyer to even take on. And they are often refused legal assistance when they actually go out and try to find it. These alternatives can result in these positive outcomes that we need with complete consumer protection. And we need to enable and scale these alternatives that are supported by common sense regulations. So we need to cut through the Gordian Knot by updating and clarifying these regulations and across the board. So what could we do with meaningful regulatory reform? Well, these justice tech companies could hire lawyers directly and offer integrated products and services with lawyer consult, review, and advice. They could have paralegals be paralegals, take on certain customer-facing tasks, meaningfully review, revise, contribute to drafting forms and documents, and elevate to lawyers as necessary. Lawyers would be part of the team, earn money and benefits, and the companies could attract talent that otherwise is going where the money and the equity is. Successful justice tech companies could then expand, and they're trying to, and they're planning to, expand to other areas of law, operate as a resource for community organizations, and subsidize low or no cost services and technology. So we could introduce across all jurisdictions the model for low-cost outcome-based solutions that leverage technology, and pro se litigants could achieve the results on legal processes that dramatically and positively impact people's lives, people who are otherwise completely shut out of the system oftentimes. We could create systems that cooperate with courts, clerks and prosecutors that would increase efficiency for the court and increase access to justice for everybody. And by the way, beyond consumer benefit, which of course should be paramount, other stakeholders would also really benefit from meaningful regulatory reform. Lawyers would benefit from new opportunities, more work-life balance, professional growth, the ability to service more of the market. Small firm lawyers are currently tasked with this enormous effort of having to balance the practice of law and complex cases in addition to managing all of things business, from paid marketing to SEO to HR needs and billing. And we want to create more opportunities that allow lawyers to do what they do best and get paid for it. So every day, innovation is being discouraged because these regulations are preventing justice tech companies from providing consumers with meaningful access to lawyers, even when the lawyers who would be employed by these companies would be bound by the same ethics and standards of care that lawyers in law firms have. So the other thing I want to mention, which gets overshadowed because it seems like a very binary approach, is that regulators would also have more oversight because they would have visibility into the entire process rather than being shut out of the visibility of so much of it. So we know that we need to support both these entrepreneurs and harness a collective voice for regulatory reform to expand the debate beyond lawyers and bars and bring the public's interest to the forefront of the conversation. So we founded Justice Technology Association earlier this year as a nonprofit trade group to support these change makers, harness technology to help people navigate legal matters, foster hope and self-empowerment, and contribute to a more fair legal system. Our mission is to democratize the consumer legal experience through the use of technology for the public good. So we've received a lot of significant support and interest. We have a strong founding board of directors and members and a really powerful advisory board that's uniting a broad range of disciplines that intersect with justice tech, from VCs and impact investors to top reform advocates, judiciary, academic innovators, journalists, and tech leaders. So organization and empowerment by these new consumer-facing providers is key to providing a public narrative for legal service reform. One example, by the way, that's practical but hugely important is that because our members are serving consumers directly, we can tap into this knowledge base and access them and leverage these incredibly powerful stories to demonstrate to the courts, the ABA, and policymakers that consumers want agency and alternatives in this area. So JTA aims to organize, centralize, and advocate for these new market participants, amplify those consumer voices, and exponentially increase their impact, which is particularly important at this moment in time. Our primary goal, by the way, is to bring together like-minded people. So if anyone has ideas on how we can collaborate to further amplify impact, please feel free to reach out. Regulatory reform should be front and center for legal tech. It's a matter of delivering legal service better. However, I just want to close by saying that there's no question that we all have to work together to fight for access to justice. We need pro bono lawyers. We need more support of self-help centers and legal service organizations. We need everybody on board. There's no single solution to this crisis, and we need more focus on consumer protection and the widespread nature of the challenges and the opportunities that we're dealing with. Thanks.
Thank you. Thank you, Maya. So we're going to hear from each of the panelists, and then we'll open for questions, but not too many questions because we're already way behind time. All right, Steve?
Yeah, I'll just keep this conversational in the interest of time. So I'm pleased to be here representing Elevate, one of the early market participants that's taken advantage of these regulatory reforms. We have the good fortune of having an ABS in the United Kingdom that we acquired in 2019, and recently were granted an ABS license in Arizona that allows us to practice in the US. What that means, and what I want to be clear for all of you that represent law firms or work directly with law firms is we're coming for you. Not really, I'm just joking. Contextual information is really important here. Why would an organization like Elevate enter this business, and why is an ABS important to us? It's really comes down to a phrase that we deeply dislike at Elevate, and that's the notion of an ALSP, the Alternative Legal Service Provider, which I think grossly understates the amount of resource and background and expertise that we can bring to solving problems of our customers, which fundamentally is the reason all of us exist, right? As legal providers, as legal services professionals, we're there to provide services for our clients. These rules we've talked about today are all about protecting our clients, and we're pleased to move beyond the realm of protection to focus more on the realm of delivering the optimized services that our clients want. So why not why do we like the term ALSP, and what do we favor in return or in exchange? ALSP kind of creates the impression that we're a alternative to some other norm, right? We like to think of ALSPs as the organizations that law firms set up internally themselves to look at the demarcation of services that they're going to split and the services that they provide. We refer to ourselves as a law company, and we view ourselves as part of kind of the triumvirate of providing services in conjunction with law firms who absolutely have a place in this ecosystem, and the legal departments that purchase services for those firms. And so the key goal here is to look at the right allocation of tasks and the right level of expertise to make sure that we provide the best services to our clients. Peter and Mary did an excellent job talking about the evolution of legal operations as a function. My important mentor and good friend Mark Chandler has been mentioned in this setting already today. Mark approached me in 2005 and asked me to take on the role of legal operations specialist at Cisco. And at the time I turned him down because there was no career path there. It turned out that putting my faith in Mark turned out to be a wonderful strategic decision for me that led to developing a completely different set of skills and levels of expertise that just didn't exist in the market at the time. And Mary did an excellent job of describing how we came together as Clock and we put that together, and now that feature set, that skill set exists in the market today and is accessible to everyone. Well, the role of the law company is just an extension of that in my mind. It creates the ability for us to provide a unified basket of services, unifying the requirements of the internal legal department or law function, the legal operations group, and the services that they get from their outside law firms. So specifically, why did we take interest in getting into the ABS market? Well, the simple answer is that lawyers are slow to adopt to change, and so many of the services that we would like to provide are benefited by the oversight. Okay, I'm overstating it. Really, it makes lawyers more comfortable to know that a law firm is sitting at the top of the chain, right? It's as simple as that. I do not believe that there's one single thing from an expertise perspective, from a delivery perspective, that requires us to be a law firm, to have an ABS. But the ability to take advantage of that ABS makes it more palatable to our customers to purchase certain services from Elevate. The other advantage of it is that we can take our process and technology expertise and have that filter down into the types of projects that Maya is sponsoring, right? A lot of the contract automation best practices, the data gathering best practices that are coming out of the legal operations functions in the corporate environment apply just as well to the problem sets that Maya is focusing on. And so I see a lot of opportunity for other ABS structures to take advantage of those skill sets in a way that's more transparent, right? Law firms, innovative law firms have been hiring people with data expertise and technology management expertise, process management experts over time in an effort to solve this problem. The regulatory changes that have taken place in Utah and Arizona simply pull back the curtain and allow us to do that in a very transparent way.
Thank you, Steve. John?
I'll do the same and skip the slides because we're all eager for a drink. So, yeah, I am the CEO of Estate Guru. We're a consumer-facing legal technology application, so we think about practicalities and not really in theory. So for us, being part of the Utah Legal Sandbox was a very practical decision. We currently operate in 49 states. We don't operate in Louisiana. They practice law a little differently down there, and we haven't adjusted our platform for that quite yet. But we work with attorneys in each of those states to deliver high-quality, customized estate plans. Typically, when you think about estate planning, it's not something that gets you up in the morning. It's pretty opaque. A lot of law firms have abandoned the practice. It turns to mom and pop shop attorneys to do the work. And in order for their structure to work as a mom and pop shop attorney is to simply charge higher fees. So they charge $1,500 to $5,000 depending on their geography, whether they're in California or in Nebraska. But typically, estate plans are needed by everybody unless you're beneath the small state affidavit limit in your state. And most people think of their estate plan as just writing a will on a piece of paper and then saying, yeah, I'm good to go. It's a problem that you don't have to deal with because you're dead, right? So you've already kicked the bucket and your beneficiaries are the ones left holding the bag. And quite frankly, most of the time, wills aren't sufficient. In most states, you'll need a trust. And whether that's an AB trust or a disclaimer trust or a married separate property trust, does it adopt or does it change for special needs children? Does it do you have a spouse that's not a foreign citizen? You have a ton of these, little pieces that, you wouldn't learn as a consumer. You wouldn't even learn that if, you're reading, the articles that come out on estate planning in the Wall Street Journal, right? It just says, get a will and go talk to a lawyer and your financial advisor should help you. And that's not a very effective delivery model. That's why over half, of Americans don't have an estate plan in place. And over 70% of those that do don't have it funded correctly. So of the people that did get their will or their document in place or their trust in place, what happens? Well, when they kick the bucket as well, just like we all do, death and taxes, the two only certain things, they're going to end up, their beneficiaries are going to end up in probate. And that eats into a large portion of the wealth that's passed from generation to generation. And that's a societal problem that's driven very much by the way that we regulate lawyers. And so in Utah, what that allowed us to do is it changes the way that we can revenue share. Our delivery method is typically B2B to C, so we'll take our software and we'll use it with wealth managers, we'll use it with life insurance companies, with accountants, people that have a vested interest in the estate plan being put in place and a vested interest in seeing a comprehensive financial plan in place, and then they will use it with their clients. The beauty about our platform, of course I'm going to evangelize ourselves here, but is we put the attorney into the code. So we haven't kicked the attorney out, even though we're in the legal sandbox in Utah. We haven't said, you don't need the attorney's advice. We say, let's put it in code and let's scale it. So let's set a system of triggers behind each of the in-tech questions that our platform will ask consumers in a consumer-facing format, just on the web. And if the client's response falls outside of these parameters, then it'll flag that question, it'll flag that attorney, and it'll say, hey, you need to discuss, and we may need to put QDOT language in here. We may need to figure out what's going on with this spendthrift beneficiary that's a drug addict. We may need to figure out all these different things that need to happen. And so we have a risk triage built into our platform. So we partner with attorneys, but more importantly, we're able to incentivize all the stakeholders from the advisor, the attorney, and the end client in a way that they can revenue share and ultimately drops fees. We charge on average $600, $650 for a trust. And that comes with the attorney's cover letter, it comes with their inclusion, it comes with that risk triage, and it comes with a bunch of additional services that you won't see in the market today being offered by attorneys. I mean, the last time I had, I went undercover a couple of years back when we began this, and I talked to a couple of attorneys as if I was a prospective client because I wanted to know the process. And one of them I was like, do you guys have anything to store my documents? How can I access them, right? And he just handed me a USB stick. And I'm like, where does this go? This is really old, right? Who uses it? It's a thumb drive, right? But for us, we're able to work and also take, and derive a lot of the analytics on the underlying assets. And that has a lot of value to life insurance companies, has a lot of value to wealth managers. And suddenly people are able to interact with their estates, and they're able to interact with things that they didn't believe were actually tangible in their lives, their 401ks, their IRAs. That's something that Bob down at Schwab takes care of. But in reality, you can see that in the context of their estate plan and say, wow, I've got a $70,000 liquidity gap in my estate, and I've got 5 bennies. I think I need another policy. And even the financial advisor's like, well, yeah, Bob, you do. You do need that. I'm glad we had this discussion. I'm glad that we put the lawyer into our practice digitally here. And so it streamlines a lot of that work. And I'll close by saying it also operationally enhances what we do 100%. The way that lawyers are regulated now, it drives up costs for legal advice. So now we can have customer service agents that are trained by our managing attorneys to answer legal questions and give legal advice, even if it's just a broadened advice from an FAQ that we create as an intake form. But I had a slide. Obviously, we're not going to see that. But essentially, it just has estate guru plus the attorney to the advisor to the consumer, and it looks like a really simple model. But that model in most other states is illegal. Only in Utah does it exist that way, because we would talk about the things that you won't see. We're seeing, price compression. It's as if lawyers are able to set. They do set the rules, but it's as if they're creating, wage control on the type of advice that we can give. And if you talk to a lawyer about wage controls, they're going to say that's illegal in every other industry, right? And so, for us, it's a cool application and a very mundane piece of law. We get it. We think estate planning is sexy. You'll have to convince us otherwise. And everybody needs it, right? But that's what we do in the Utah Legal Sandbox, has allowed us to innovate and think about ways to make consumer-facing legal tech more accessible. Ultimately, when you look at the broad range of technology options that lawyers have at their disposal, all the way from computable contracts that we've talked about today to blockchain applications, a lot of those are geared towards enabling the attorney, to move at a quicker speed. What we want to do is replicate the attorney in every instance without the attorney knowing that they've been replicated. And I don't want to create like a huge, thing about that, but that's what we do in the Utah Legal Sandbox. Has been awesome. It's very curious because I went to BYU, so it happened in my backyard, so we had no choice almost but to join. So,
Right. So let's open it for questions. We're beyond our time, but not much because this was very efficient. Questions? Let's start here.
Thanks so much for this talk, and everything you're saying resonates with me a lot because I also work in a legal tech company. And my question to you, Steve, you were talking about how companies are here to get the law firms and stuff, but I want to ask you, how can most important part, how can legal tech help law firms get a competitive edge over others and provide more sort of data-driven solutions rather than treating it as a threat to them?
It's a great question. There's a couple of observations that come to mind. One is, when I started my legal practice, I assumed that every time I sat down to solve a problem, I would start with a blank sheet of paper. And that hasn't happened since I graduated from law school, right? You want to take advantage of the replicable, important elements of what you're producing, right? We're here to produce outcomes for our clients. We're not here to measure the value of our inputs, and that's a different conversation that I've had many times. But the goal of making this applicable to lawyers and attractive to lawyers, I think, is to help. Let's be honest, there's a lot of what we do as practicing lawyers that we find rote and mundane, right? And so the goal here is to disaggregate the tasks in a way that technology can solve problems where it's appropriate, where we can delegate tasks appropriately, and that's been common through the paralegal process over generations. And then really focus, as was described earlier, on the bespoke aspects of what we do. Far too often we pretend that we're creating art as lawyers, and really our clients don't need art, they need prints. There's a limited number of circumstances where art is required.
that's a really good question. That's a really good answer. I don't know that I can change that. I'm probably going to use that.
You should use that.
Yeah.
Over here.
Lucy, super exciting slide to see these regulatory evolutions happening at its glacial pace. What's the state of this battle? Are we at risk of losing the sandbox? Is this a done deal? where are we at in that evolution? Jonathan, Steve, do you wake up at night afraid that this regulatory, like, exclusionary zone will go away?
So, I mean, I think observers of this will always remember Washington's triple LTs, and we know that rules can be changed and changed back again. That said, in terms of Utah and Arizona, there's real commitment from leadership, and by leadership I mean the state Supreme Courts. I mean, you know, we had one justice in Utah who is now retired from the bench, but all of the others are fully on board. And so I feel really good about it. I mean, I think we've tried to build a model in Utah for the sandbox that is a proper regulator, in that we really are pulling data from our regulated entities on a regular basis. We are looking for evidence of consumer harm. It's really different from how lawyers are regulated. But it's meant to be pretty heavy in the front in the sandbox space, but then once they're out, it's a much lighter touch. And so I think, you know, we've tried to build a model that is effective but sustainable, and I hope that we've done it. I think I have real faith in Utah and Arizona. Other states, I don't know. I mean, I think that's the big question. I think what we're seeing now is a lot of, well, let's see what happens in Utah and Arizona. And I think the challenge will be, the data is good. Like, we put out reports. All of you should go to our website, utahinnovationoffice.org. Every month we put out a public-facing report. This is how many services. There's been over 16,000 services across 10,000 individual clients in the past 2 years. And so they've touched almost every county in Utah, including legal deserts. And so we're pulling that data. We can see it. We can push it out. What'll be really interesting is to say, okay, here's the data, it's great, and then what, you know? I think the other piece is you really need judicial leadership, and those states that are up there on that, that were on my slide, I think we are seeing that. We're seeing in Michigan and Oregon, Michigan, and even in Washington, you know, some judicial leadership on this. So I think I'm like very optimistic and then like a little bit cautious.
I can answer a little bit of that. No, I don't wake up in the morning fearing it'll go away. I know Lucy well, and so I think she'd give me the heads up if I ticked her off. But no, I think the most important thing for us is to cultivate the good graces of our consumers and to report that data back. And as that data gets out, I think responsible judiciaries will look at that data and say, wow, this didn't create harm to consumers. As long as entrants like Steve and myself are cultivating the good grace of our consumers, and to speak to how that's actually done in practice. We want, our platform involves the attorney. So we're trying to scale competent representation. We're saying no to document engines in general. We're saying that's not good enough. And so as long as we can find solutions that work with attorneys and involve the attorney and scale competent representation, I feel like in the long run that will deliver access to justice returns across different states besides Utah and Arizona.
Yeah, sorry, real quick. That's a really good point, because I think that's another reason that I really wanted to make sure Maya and the Justice Tech was front and center, because getting that, the consumer voice has been absolutely not in these debates at all. It's lawyers debating with lawyers about what the proper regulatory approach is. Like, and Maya's group is explicitly focused on bringing that consumer voice to the forefront and organizing it, and saying to the courts, to the bar, to the legislatures, to the lawyer legislatures, it is not good enough. Your arguments are not good enough. Our voices matter. So that's really important.
That's what we're doing.
Go ahead. You want to add to that?
Oh, no, there was a question back there. I don't know if it was a follow-up.
Yeah, okay. But one of, who's going to, question back?
On the financial services side, I think there's a path for proof of concept in the pipeline for the sandbox. Is that something that's of value in the legal industry? It seems to have a nice incubator quality to it. Was that ever been considered or a part of any prospective sandbox?
Yeah, so the sandbox was, it came out of kind of left field at this meeting we were at in Utah, from Margaret really. Yes, so there, obviously the most mature sandboxes across the world are in the fintech space. And really the theory for sandboxes is that you allow sophisticated innovation around technology that for which the regulatory framework doesn't really have a proper approach to occur, and feed data back in that will inform policymaking. Now, whether those sandboxes actually do that or not is, I think, a fair question to ask. That is explicitly what this legal sandbox in Utah is meant to do. So, it's not only a sandbox for the entities that are within it, but it's also a sandbox for our regulatory framework, which is this kind of data-driven framework. So yeah, I mean, I think we're definitely, I think there's 2 legal sandboxes in the UK, and there's 4 in Canada, and then there's us. So it's starting to creep into legal, and I hope actually that the Utah model will be very influential, because we really thought through all of the pieces around this regulatory framework and how we elucidate consumer harm.
I think in those cases too, in the UK, you get access to sample data sets. I'm thinking the legal profession is actually too diverse and actually not as regulated as securities, making that maybe less likely to happen, but maybe I'm wrong about that. I mean, docket data may be helpful to some folks, but I'm guessing maybe not to a state guru.
Yeah, no, it's a good point. The UK's, the law tech sandbox is actually it's kind of a different model. It's more helping, providing access to government and government data, which, I think would be a great sandbox 2.0 for Utah. Right now, we're just trying to get this framework off the ground. But I think I agree with you. I think the data piece is a big, outstanding need to do on the list.
I can just add to that. I mean, I think that the regulatory sandboxes in Utah and Arizona are delivering these key openings to innovation, but we need to go further because, of course, I'm going to say that, right? But currently these state sandboxes can't be leveraged right now to go national for state-specific things other than federal, like trademarks or immigration. That ABS model really works very well. But these companies are still doing these battles, state by state by state, and it's really taking longer than it should.
Okay. Bruce, last question.
Do we have a good compilation over, the last 25 years of harms caused and avoided by UPL? Is there some empirical Pandora's box that somebody has in defense of UPL that says, here's the parade of horribles that have happened, aside from violating the UPL laws, strictures? What happened to the client who was served by a non-lawyer, and how bad was the harm, so that you can calibrate empirically, just like we would in a medical pandemic kind of thing that could happen, where you're looking at the degree of harm from various practices. What have the people holding on to UPL as a guild done to justify holding on to it empirically?
So it's a good question, Bruce. I think actually, so Deborah Rohde, when she first got her license in '81, I believe, Jason, tell me if I'm wrong, wrote one of the first empirical studies of unauthorized practice of law and really challenged this notion that UPL restrictions are based in the public interest. And then she and I did a reboot of that 2014, I think it was, or 2015, looking again, interviewing the folks who are responsible for enforcement of UPL across states, asking them, okay, well, who brought the claim, the complaint, what was the harm alleged, and it's been a while since I've looked at the paper, but generally very low percentage of actual harm alleged, with the exception of immigration. I think that is the space where there's more. It's actually followed through to discern, or it's taken the time to discern that and articulate that public harm. But no, for the most part, at least in the studies that Deborah did, it was lawyers complaining about, But that's slightly different what you were saying, which is, and the answer is no. From the other side, there's very little empirical, if any.
probably, yeah, and it's probably far outweighed by the number of, professional discipline
Right, we do-
numbers that we have
right.
for actually barred attorneys.
We have data on
Yeah.
harm done to clients by licensed lawyers. We have lots of that, and we have the reputation and the jokes and all of that about lawyers and their own ethics. One of the issues that's come up in this discussion is the absence of an organized group that is lobbying for change in the rules. There are organized groups lobbying to hold on to the status quo. They are people who benefit from the status quo. And they're not Lauren and Ralph, who are, because the big firms are not as limited by these rules, although we'd be able to attract better talent even than we do with different rules. But it's organized, small firms, sole practitioners, the people who John wants to compete with, or doesn't, John doesn't compete with them, John collaborates with them, but
There we go.
but those are the people, and they are organized, and they use litigation as a weapon. The rule that prohibiting unauthorized practice of law puts everybody in fear that the way they organize their service may end up with somebody doing something that is the practice of law, which is deliberately vague in the statutes, and so people are deterred from building organizations and doing different things. All right, let's thank this panel. This was a great panel for the end of the day. And I'd like to say, as the last panel, just say one final time a thank you to Roland and the entire team that put on FutureLaw. I've been coming to this for a long time, and I think this was one of the best programs we've ever had.